If you're staring at a felony DWI charge in Texas, you're probably bouncing between two bad thoughts. Am I going to prison? And is this going to wreck my job, my license, and my record for good? And the worst part is, it can feel like the state already decided you're guilty because there's a breath test, a blood draw, or a crash report, and everyone's telling you felony means you're done. I'm Barrett, a Texas criminal defense attorney, and I handled DWI cases just like this. In this video, I'm going to walk you through the exact pressure points that actually win felony DWI cases in Texas, what the prosecutor has to prove, where these cases usually break, and what you need to do immediately so you don't accidentally hand the state the missing piece they need to convict you. Let's get right into it. A felony DWI in Texas can feel like the system already decided you're guilty, and that's exactly when people make the biggest mistake. They panic, assume it's hopeless, and take the first deal just to make the fear stop. But felony DWI cases get beaten the same way any serious case gets beaten. You stop treating the accusation like proof. You make the state prove it, cleanly, legally, and beyond a reasonable doubt. And you look for pressure points, the stop, the tests, the video, the procedure, and in felony cases especially, the prior convictions the state needs to even call this a felony. What makes a DWI a felony in Texas? Not every DWI is a felony. In Texas, it typically becomes a felony because of what's in the background or what was involved in the situation. The most common path is prior DWIs. If the state is saying this is your third DWI or more, that's when they try to elevate it into felony territory. Another path is the child passenger situation. If they're alleging you had a child under 15 in the car, that can change the level of the case fast, even if it's a first DWI. And if there was a serious crash, injury, or death, you may be dealing with different felony charges entirely, like intoxication assault or intoxication manslaughter. To put that in perspective, imagine this. You're heading home after a night out. You've had a few drinks and you get pulled over. You have 2 prior DWIs from years ago. It doesn't matter if those were 5 years back or 15. If the state can prove them, you're suddenly facing felony charges. Or say you're driving your niece home from practice and you get stopped after a couple of beers. Having a child in the car can turn it into a felony case fast. Here's the key point. In a felony DWI, the state often has more moving parts to prove. That means more chances for them to mess it up, and more chances for you to fight. Understand what the prosecutor has to prove. The very first thing you need to know is this: the DA has the burden of proof. To convict you, they have to prove every element beyond a reasonable doubt. This is not a guessing game. If there's doubt, the jury is supposed to find you not guilty. In general, the prosecutor is trying to prove you were operating a motor vehicle in a public place, you were intoxicated while doing it, and it's felony level because it's a third DWI, or there was a child under 15, or someone was seriously injured or killed. It sounds straightforward, but it's not always that simple. Mistakes get made, evidence gets mishandled, and sometimes the basic facts aren't as solid as they look on paper. I've handled cases where everything looked tough, until we dug in and we realized the officer never actually saw the person driving. They were sitting in the driver's seat, parked, engine off, and the state couldn't prove operation. The point is, don't assume your case is ironclad just because you got arrested. The way you beat a felony DWI. Felony DWI cases don't usually collapse because of one magic argument. They collapse because the defense attacks the foundation from multiple angles. If we knock out one major piece, the whole case changes. If we knock out 2, the state starts negotiating for real. And sometimes, if the right piece gets suppressed or excluded, the case can't stand at all. So let's walk through the strategies that actually matter. Strategy 1, challenge the stop. The first question is always, why did they pull you over? In Texas, an officer can't legally stop you just because it's late at night, or because you left a bar parking lot, or because they had a feeling. They need a lawful reason. Reasonable suspicion. And this is one of the most overlooked opportunities in a DWI case, because if the stop is bad, evidence that came after it can become unusable. I've had cases where the report sounded solid, and then we watched the dash cam and realized the driving was completely normal. No swerving, no speeding, no traffic violation, just a stop that never should have happened. That's when we file a motion to suppress. And if the judge agrees that the stop was illegal, the state can lose the field tests, the statements, and sometimes the entire case momentum. Short version: if the stop is weak, everything after it is vulnerable. Strategy 2, challenge the arrest. Even if the stop was legal, the arrest still has rules. Police need probable cause that you were intoxicated, and every detail matters. If the only evidence is smell of alcohol, that's not automatically enough. If the report has errors, if officers contradict each other, if the video doesn't match the story, those are pressure points. A strong defense digs into every second of body cam footage in every line of the report. If the arrest is shaky, we push to have the case thrown out or heavily weakened before it ever reaches a jury. Strategy 3, attack the prior convictions. This is where felony DWI cases are different. If the state is calling this a felony because of priors, they don't get to wave their hand and say, oh, trust us. They have to prove those prior convictions the right way. They have to prove that they're the right priors, tied to the right person, with the right paperwork, and in the right court, and that they legally count. And yes, priors can be challenged. Sometimes the records are incomplete, sometimes the paperwork is sloppy, sometimes the state can't properly connect the prior to you. Sometimes an old case has issues that make it unusable for enhancement purposes. I've handled cases where one prior was out of state, old, and the records were missing key proof. When the state couldn't cleanly prove it, the felony enhancement weakened, the whole case changed. Because if they can't prove the priors cleanly, the felony label can be on shaky ground. And when the felony label gets shaky, negotiations change fast. Strategy 4, fight the field sobriety tests. Now let's talk about the roadside tests. Walking a line, standing on one leg, following a pen with your eyes. These tests get treated like science, but they're performed in the worst conditions possible. Uneven pavement, bad lighting, wind, rain, flashing lights, nerves, stress, sometimes injuries, sometimes medical issues, sometimes age, weight, or footwear. And here's what people don't realize. Officers are supposed to give these tests in a standardized way. When they rush it, skip tests, or give bad instructions, the tests stop being reliable. I've had cases where the video showed the officer giving confusing directions, talking over the person, or cutting the test short and calling it a fail anyway. And juries can see that. Once a jury stops trusting the field tests, the whole probable cause story starts to look like a guess instead of proof. Strategy 5, challenging breath and blood testing. This is the part that scares people the most, and I get it, but testing evidence is not perfect. Breath machines require proper maintenance, proper procedures, and proper operation. And things like mouth alcohol, certain medications, or even timing can matter. Blood evidence requires proper collection, proper storage, proper documentation, and a clean chain of custody. If any link in that chain is weak, say who handled it, where it sat, how it was stored, whether the records match, well then the results become something that we can challenge. I've seen labs mishandle timelines. I've seen paperwork missing critical details. I've seen chain of custody gaps where the state couldn't clearly account for where the sample was and who touched it. And when that happens, the test result goes from a slam dunk to questionable. Even a small problem can be big in court when the state is leaning on a number to win. Strategy 6, use the video to break the narrative. This strategy is simple, but it's powerful. Police reports are written to support arrests. Video shows what actually happened. Body cam and dash cam can make or break a felony DWI case because it reveals what the report leaves out. I've handled cases where the report claims slurred speech, stumbling, and confusion, and the video showed calm, clear speech and steady movement. And when the video contradicts the report, it does two things. It damages the officer's credibility, and it forces the prosecutor to picture a jury watching that same footage. And that's leverage. And leverage is how cases move. Strategy 7, look for procedural mistakes. Even in a felony case, the rules still apply. Officers have to follow proper procedures. Warrants need to be done correctly. Timelines matter. Detention has limits. Statements can become inadmissible if they're taken the wrong way and at the wrong time, and evidence has to be handled properly. And the thing about procedure is this: it doesn't care how serious the accusation is. If the state's evidence was gathered illegally or handled improperly, that evidence can be limited or excluded. Sometimes that doesn't end the case, but it can absolutely change the case. And changing the case is how you protect your future. Strategy 8, build your defense story. Now let's talk about you, because felony DWI cases aren't fought on paperwork alone. Jurors are deciding what they believe happened and who they believe you are. If there's a medical issue that explains symptoms, we document it. If there's anxiety that affects performance on tests, well, we explain it. If there's a condition like diabetes that can mimic impairment, we prove it with records and professionals. And even if the case is negotiated, your life still matters in the outcome. Your job, your family, your treatment efforts, your stability, your accountability. You're not a case number, and you're not a label. A strong defense makes sure the court sees the whole human being, not just the allegation. Strategy 9. Sometimes the goal is beating the case outright. And sometimes the goal is forcing the state into a result that saves your life from the worst consequences. Negotiation is not giving up. Negotiation is strategy. But here's the rule. You negotiate from strength, not from fear. You do not take the first offer just because it's sitting there. You take the offer that matches your real risk after the evidence has been tested, challenged, and pressure has been applied. That's how you avoid a plea that you regret for the next decade. What you should do next. If you're facing a felony DWI in Texas, your next steps matter more than you think. Don't talk about the facts of your case to police or investigators without your attorney. Start preserving anything that could help. Names, locations, receipts, timelines, medical records, anything you remember. And make sure your defense is being built around the actual evidence, not the assumptions in the report. Because felony DWI cases can be defended, but the defense has to start early and it has to be done on purpose. Felony DWI in Texas is serious because it can carry prison exposure and a permanent record. But a felony charge is not the same thing as a felony conviction. The strategies that move these cases are the ones that attack the foundation. That is the legality of the stop, the legality of the arrest, the reliability of the field tests, the weaknesses in blood and breath testing, the credibility gaps between reports and video, and in many felony cases, whether the state can even prove the priors the way the law requires. When you fight it the right way, you create real paths to protect your freedom and your future. And if you want to understand one of the smartest plea options that sometimes comes up in Texas DWI cases, having a DWI reduced to obstruction of a highway, watch the next video. DWI reduced to obstruction of a highway. Is it worth it? That video can help you avoid a plea you'll regret and understand what you're really giving up or saving before you sign anything. I'll see you in the next one.